My lord, the simile which was sought to be given, that your lordships are visitor to some university, my lord, is not the simile in the context, is not the correct simile in the context of the question your lordships are deciding. The question is, who is the ultimate decision-making authority in terms of administration?
There are two ways to look at administration.
My lords.
One is with whom the absolute or the final power is vested.
Correct, my lords.
The other is day-to-day administration, day-to-day running, functioning of the institution. The day-to-day functioning is done by the people who are at helm of affairs, who are hands-on. Lord Rector, being the Governor General or somebody, will be having numerous functions.
Correct, my lord. On site, who is, my lord, either of them, my lord, there is no dominant.
So, as per your argument, it's going to be the ultimate authorities and not the ones who are, because this argument proceeds on the basis of the one who are actually running the day-to-day administration. Like in criminal law, the persons in charge of and responsible for administration are the ones who can be prosecuted. Day-to-day affairs of administration,
Right.
and not the one who's overall in charge, or not the one who's a symbolic in charge.
Yes. My lord, even day-to-day
Your argument, which is to be answered.
Please.
Stop. My lord, this has to
No, Mr.
What?
Lord, my decency
I hope
be
we'll
not
get the
treated
time.
as my weakness.
That's fine.
Mr.
He's not responding to our argument.
Mr.
I hope we'll get the time.
Dr. Lavan, we'll hear you and rejoin. There's no difficulty. We'll hear you. Yes.
Lord, here, even day-to-day administration is not in their hands. Lord, the court was consist of some 100 and some odd, my lord, people. But they can't be running the...
Mr. Solicitor, the argument which was made on the other side was this, that you can establish institutions of your choice and you have a constitutional discretion to administer it. But if you give that discretion, exercise that discretion by giving the administration to others who do not belong to a minority, that does not detract from your position under Article 30. For instance, in any educational institution, there will be non-minorities who will be an accountant, who will be performing other ancillary functions. That by itself may not be an indicator that you cease to be a minority.
Even that discretion is not there. That's what attempt, my lord.
Yeah, of course, you have said that, here the statute superimposes the Lord Rector. And
Yes.
We'll hear the other side.
I'm saying something else. Lord, something else as well. Even in terms of amending the statutes, they have no supremacy. They can amend the statute. It is always subject to the rector, the Governor General in Council, full right to set aside it, remit it back, or say that I don't accept it, reject it. So meaning thereby they had a kind of advisory function. This is what we think the statute should be, and according to us, this is how the administration may run. For example, the statute concerns the administration. That also, my lord, the discretion also is not conferred. Please, my lord, see further.
Obviously, it was the policy of the British government to not make this an absolutely autonomous institute. They were retaining some element of control over the institute.
Substantial and predominant, that's my submission, control. And my lord, this statute be not examined, my lord, my respectful submission, in the context of or under Article 30. It was not there. If any Parliament were to make this statute, possibly an argument, not possibly, argument can be made that this is violating of Article 30. But there is a history behind it, that we will have control and there would be no denominational character. Are you agreeable? They said, yes, we are agreeable.
Anyway, there is no challenge to the provisions of the Act.
There is none. Even the
Therefore, we proceed on the basis that the Act is valid.
Amendment is not under challenge. Post-Constitution amendment is not challenged under, except 81 amendment.
So we take the Act as it stands and see what is the impact on its minority status.
Yeah, kindly, my lord. Therefore, my lord, kindly see, my lord, para 8. The power to establish and maintain colleges and schools was subject to...
If a similar provision were to be made today, would that detract from the minority status of the institution?
It may, my lord, it may. My lord, the government may not, my lord. The present government under the Constitution cannot compel them that either of these things to you agree, otherwise will not pass an act. I am not for a second saying that that's the prerogative. The legislature may in its wisdom say that we will accept this or we will not accept this, but subject to judicial review. But in 20, the crown, the
Test would
British,
be this. The true test would be this. Which of these provisions are relatable to the overall regulatory power of the state, which even Article 30 allows, and which of these provisions go beyond what is really a regulatory provision, which is agnostic to religion,
correct, my lords,
and then destroys the minority character.
correct, my lords, but please, my lord, again, my lord, at the cost of repetition, please do not read 1920 Act in the context of Article 30. It is at a period of time in history where Article 30 was not there. Indian Constitution was not there. There was no concept of minority. There was no concept of fundamental rights. And the British governments was in a position to put its terms. If you want this, have it. Otherwise, others did not agree. They started their own universities and started conferring degrees because till 56, it was not impermissible to have universities and degrees. This degree was needed by the aligarh Muslim
So,
University.
really speaking, what your contention boils down to is this, that this was not a denominational institution when the university is established in 1920. Therefore, the subsequent development, namely the adoption of the Constitution on 26th of January 1950, cannot confer upon it a denominational character for the reason that you had surrendered that denomination.
And that is the ratio in Basha.
That is your submission, which we got the point. We'll have to hear the rejoinder.
Lord, kindly, just quickly, my lord.
Yes.
Section 12.
See, let's see section 12.
Section 12, my lord. 3, my lord. The most important power for any university is to affiliate other colleges, etc., my lord. That's the most important administrative power. Please see. The university shall, subject to statutes, have power to establish and maintain intermediate colleges and schools within such limits in the Aligarh district as may be laid down in the ordinances for the purpose of preparing students for admission to the university, and may provide for instruction in the Muslim religion and theology in any colleges and schools with the approval of the academic council and the sanction of Governor General in Council on the recommendation of the visiting board, and subject to such conditions as may be prescribed by the statutes and ordinances, the university may admit. So, my lord, first supervening power of Governor General in Council, this is the major administrative act. Thereafter, the visiting board, and subject to the statute, and your lordships would recall, the first statutes were framed by the imperial parliament itself, providing that you cannot amend that statute without my permission. Even the ordinances were framed by the Governor General in Council. So please come to page 4.
Didn't want to give a complete free hand, they realize the importance of education and the impact they'll have because
They wanted a degree, and for that degree had a price in those days, price not in terms of money, that you have to accept what
perhaps
government
more
says.
than that. It was perhaps more than that. They wanted to have control, overall supervisory control, so that they could intervene and interfere.
In the administration, there was no absolute discretionary administrative power conferred under 1920 Act. And the history, my lord, is the proof of that. That we will have two things, no denominational character, and we will have administrative control. And they were in a bargaining position. There was no constitution. Having a minority institution or having a university was never a fundamental right. And majority of them did not do it. They accepted, my lord. And I wanted to cite, but I am not citing, my lord. I request somebody else to cite. My lord, one of the latest written by the then management to the governor, my lord, is shocking. That we want that your British administration continues in this country forever. It's a boon for our nation, etc. But I don't want to, my lord, digress from that. My colleagues are citing it. Please come to page 4. So that was, my lord, the mindset or the object which they are entitled to have. They were entitled to have.
Basically, this is a pre-constitution institution.
My lord.
we will have institutions which are claiming the right under Article 30. Any institution which fulfills the requirements of Article 30 is entitled to claim a right post-Constitution, irrespective of whether it has been established prior to the Constitution or after that. The law is not that you can claim the right under Article 30 only if you have been established after 1950. Now we are dealing here with a pre-constitution institution. Second, an institution which is governed by a statute.
Correct.
Now, there are certain, and we are looking at the antecedent facts prior to the onset of the Constitution, prior to the adoption of the Constitution. We have to also understand that that was a period when there was absolute control which vested in the imperial power, right? Now, to what extent was this absolute power, which was yielded by the then imperial government, so destructive of any claim in regard to minority status post-Constitution? So, contrary to what you are saying, we are not applying Article 50 to a situation pre-Constitution. To a certain extent, you have to do that exercise. Otherwise, we will be coming to the conclusion that no pre-Constitution institution can claim a constitutional right under Article 30. That's not the position. We can't say that a pre-Constitution institution is not entitled to claim the right under Article 30 of the Constitution. Obviously, they are. So long as they satisfy two yardsticks, namely of being established by a minority and two, being administered by a minority. And now here, there is an issue because you're placing in issue the fact that this was really an institution which is established by the statute, according to you. That's what the preamble
They had
said.
other options of establishment.
That they need not have gone the statutory way. According to you, they could have followed the Vishwa Bharati route. You could have,
Yes.
or any other institution.
I'll not surrender my rights and
Where
they claim
you
their
don't,
right
seek,
after
you don't seek recognition of your degrees, in which case you could have just said, well, I'm going to be an institution which will be standing alone on my degrees, even if they're not recognized.
Stephen did it.
My students will not get government service, but so be it. Many other institutions did it. Stephens did it. Vishwa Bharati did it. That's one aspect of the matter. But does the fact that they really chose the statutory way, is that so destructive of their claim to minority status? Post-Constitution.
Your lordships, with a profound
In which case, we will be saying that once you accept the fact that you will be governed by a regulatory statute for the purpose of the
It's not
conferment
a
of
regulatory
degrees,
statute.
it is a regulatory statute.
No, it's a substantive statute providing for substantive either power or lack of power.
But regulatory statutes are also substantive. They're not procedural.
There are three things, my lord, in this statute of 1920.
Does that completely destroy its claim of minority status?
Correct.
Or are these provisions which are designed to ensure the proper administration? Now, Governor General, let's take the case of the Governor General. You will find in a large number of institutions today, there is an approval required of a government officer, minister in charge of education. Are these really, in that sense, are they controlling influences? Or are they in the manner of an overall supervising influence to ensure that nothing drastic is done? We must also understand that the British government had sensitivities. They didn't want any one institution in India to become so powerful so as to affect the imperial dominion power.
No, they say otherwise.
They were not running these institutions.
I'll answer that.
This was all designed to ensure ultimately that no institution went out of the mainstream as they wanted it.
No, my lord, and some movements which were started doesn't spread across the nation. That was the reason, the movement of independence, and that was the reason why most of them said, no, we would prefer movement and not your.
Therefore, all the regulatory statutes were intended to provide one overarching objective, and that objective was nothing should be done to destroy the hegemony of the imperial government and the colonial power. Protect the colonial power.
Maybe as a general
And
purpose.
education is a very important source of it's a power, source of cultural power. And we have seen it pre-independence and we have seen it post-independence.
May I answer your lordship's question? Lord, first of all, the establishment is a fact which is pre-independence, which cannot be wished away even after the independence. How it was established? Number one. Number two, in my most respectful but very emphatic submission, these are not regulatory provisions. These are substantive provisions, either conferring powers or not conferring powers. Number three, when we talk of administration, Lord, we never talk of administration in air. Administration is always a layered exercise. For example, my lords, administration of a court, let's say for a particular high court, there would be 5 registrar generals, registrars having different powers. They would be administering, but according to what? According to something which is decided by some higher authority. That higher authority would not be doing on day-to-day basis the administration. Thereafter, the administration would percolate, but ultimately the controlling thing would be the statutes. Controlling thing would be, in case of a high court, the resolutions, the constitution, etc., passed by the competent authority who has the ultimate control. So, my lord, please, my lord, do not take these as mere regulatory provisions. These are substantive provisions. Either we confer these rights A, B, C, D. You are not supposed to do X, Y, Z. It's very clear. These are power conferring substantive provisions under the 1920 Act, not just regulating who will administer.